Hello guys, welcome to this video. In this video we are going to look at another administrative law case. We are going to look at the case of Secretary of State for Home Department versus Leech. So a short preview of the case is that we have Mark Francis Leech as the applicant for judicial review. The issue involved in this case is that is Rule 33(3) of the prison rules permitting the reading and stopping of a prisoner's letter to and from solicitors ultra-vires. This rule made it that every letter that a prisoner writes or receives should be read and stopped first to see whether it is right or wrong. So this was the issue. So this case took place in 1993. Let us proceed and look at the details of the case. So the issue here is whether Rule 33 Part 3 of the prison rules, which permits the reading and stopping of prisoners' letter to solicitors and letters from solicitors to prisoners, is ultra-vires. Section 47(1) of the Prison Act of 1952 and violates Article 8 of the European Convention of Human Rights. Let's look at the facts of the case. Section 47(1) of the Prison Acts 1952 empowers the Secretary of State to make rules and regulations concerning the management of prisons. Rule 33 Part 3 of the prisons rules provide that every letter or communication to or from a prisoner may be read or examined by the governor or an officer deputed by him, and the governor may stop any letter or communication on the ground that its contents are objectionable or that it is of inordinate length. A group of rules contained in Rules 33 to 37A deal with prisoners' correspondence and visits. Regulation 34 deals with the number of personal visits which a prisoner may receive and the number of personal letters which a prisoners may send or receive. Regulation 37A was added as a result of the decision of the European Court of Human Rights. On 2nd July 1990, Mark Francis Leech launched an application for leave to apply for judicial review. On 29th November 1990, Mr. Justice Garland granted Mr. Leech leave to move for judicial review. The judge dismissed the application. On 10th April 1992, he was convicted and sent to a sentence of 7 years imposed on him. So here is the decision. The court held that Rule 33(3) is ultra-vires, Section 47(1) of the Prison Act 1952, and violates Article 8 of the European Convention of Human Rights. Section 47(1) of the Prison Act 1952 confers a power of rule making which may limit a prisoner's general civil rights in respect of the confidentiality of correspondence. However, the authorized intrusion must be minimum necessary to ensure that the correspondence is in truth bona fide legal correspondence. Rule 33 Part 3 permits reading and stopping of prisoners' letters to solicitors and letters from solicitors to prisoners. The right to stop letters on the ground of objectionality or prolixity means that access to a solicitor by the medium of correspondence can be denied altogether. The court held that a rule along broadly similar lines would be within the scope of the rulemaking power under Section 47(1), but Rule 33(3) goes beyond the proper limits of Section 47(1). The court allowed the appeal and granted a declaration that Rule 33 Part 3 is ultra-vires so far as it purports to apply to correspondence between prisoners and their legal advisors. Thank you for watching this video. Like, share and subscribe.